that he has represented the state of West Bengal and also the Union of India in multiple litigations. It is to be noted that my Lord Justice Datta was a guest lecturer who taught constitutional law at University of College of Law in University of Calcutta for 2 years. And then in June 2006, my Lord has been elevated as judge of High Court of Calcutta and then appointed as the Chief Justice of the Bombay High Court on 28 April 2020 and then thereafter to the Honorable Supreme Court of India on 12 December 2022. Justice Datta has immense value for the liberty of each citizen of this country, as a notable judgment in Bombay High Court, my Lord has said, as it is the dignity of an individual, even after he is dead, cannot be left to mercy of the reporters, the same being part of Article 21 has to be protected. And in a recent judgment in Muhammad Anzur Rahman, my Lord has to pen down the recent growing trend of reopening the cases by filing miscellaneous application and IA after the criminal appeal or civil appeal being disposed of, in which my Lord has briefly said that if the Supreme Court adopt this practice, the very purpose of having Article 141 of Constitution would defeat. And now I move on to Mr. Sajan Puvaya, who's a senior advocate here. He has a distinguished practice on constitutional, corporate, and commercial law, practiced before the Supreme Court of India and several high courts across the country. And he has been the youngest Additional Advocate General to be appointed for the state of Karnataka and also the youngest to be designated as a senior advocate. Mr. Puvaya graduated with a bachelor's degree in Arts and Science, Arts and Honors degree from NLSIU Bangalore, and had a gold medal for academic excellence. And Mr. Puvaya practice spans broad spectrum domains including constitutional law and money laundering, white-collar crime. He regularly represents leading transnational and domestic corporations before the Supreme Court of India and national tribunals and multiple high courts. And we also have today with us Mr. Bari Ranganathan, who is a senior advocate practicing in the Supreme Court and the Delhi High Court. He also does a lot of work in the energy sectors, especially electricity and gas. He also does a fair amount of work in other infrastructural sectors such as aviation and admiralty. And we have Ms. Arundhati Gajju, who is a senior advocate practicing in Supreme Court and Delhi High Court, and who has practice spans constitutional, criminal, and white-collar crime and commercial litigation. And it is a very honor and privilege to have all of them in board. So now I would like to felicitate Justice Dibanga Datta with a bouquet. I call upon Mr. Manish Kumar, advocate on record, to give a bouquet to Justice Dibanga Datta ji. Now I call upon Mr. Chitranchul to give a bouquet to Mr. Sajan Puvaya. And I call upon Mr. Kunal Chima to give a bouquet to Mr. Bari Ranganathan. And now I call upon Mrs. Priyadashmi Nair to give a bouquet to Ms. Arundhati Gajju ma'am. Please be seated. Going forward with the panel discussion, today's topic is artificial intelligence, so which has a pivotal role in both daily life and the legal profession. This integration offers efficiency in legal research, document management, and language accessibility. However, it has also have a risk of ethical risk, including algorithmic bias. But in today's world, we cannot completely ignore the AI's intervention. So, with this note, I call upon Justice Dibangadatta to give a short, brief introductory note.
Distinguished speakers on the dais, Mr. Vipin Nair, President SCORA, distinguished guests, ladies and gentlemen. First of all, Mr. Nair, thank you very much for giving us this opportunity to share the dais and getting an opportunity to discuss with the members of the bar on something which is very relevant. And I have with me three of India's finest scholars who would be discussing what might be termed as a hot potato topic for the last few years. And as you can find, sitting with a tab, Madam also appears in court with a tab, but I rely on the physical files. So therefore, along with you, it could be a learning process for me, how to find the correct balance between tech efficiency and professional integrity. That's most important. Now, as Mr. Raja has said, the intersection of law, lawyers, AI has been transforming the legal landscape. It has revolutionized research, mainly research, I would say, review of documents, drafting, analysis, etc., etc. How do we deploy AI is the question. Because after all, being lawyers, being students of law and being part of the highest court of the land, we all owe a high sense of responsibility to our institution. It's not that, when this thing came in 1990s, you all know, it was only a communication device. Now it has almost overpowered us. Let us also not allow AI to do that. This is what would be the theme of the discussion. I would request Mr. Raja now to take over.
Thank you much. Check. So, starting with Justice Dibangadatta ji. Like we know, we don't use AI as much we use in this time. Like, how do you use AI in your life? Apart from, yes.
Very interesting. First thing first, even at this age, I use AI to gain a command over the language, that is English. After all, it's a foreign language. I may have studied in an English medium school, but even so, when a judgment is being rendered by the Supreme Court in English, and nowadays Supreme Court judgments are read all over the world, so we must avoid loose expressions. Sometimes, while dictating, we still dictate, or there are several judges, including myself also, we dictate the initial parts, the analysis part. This is a secret that I am now divulging. The analysis part, I do it myself on my laptop. Why is this so? Because when I was a junior, I couldn't afford a stenographer. And this must have been the case with several others. We used to write the petition, the plaint by hand, and that I can say even now with conviction, what you write by your hand is the best product. So therefore, first of all, I try to gain command over the language. Secondly, I try to perfect my expressions. That is also the important aspect of using an AI tool. And lastly, research is one of the most advantageous things for a judge. But nowadays we have law clerks. Our researches are done by the law clerks, we refine it. So therefore, one has to know how to harness the potential of AI and put it to really good use.
Now, I put the same question to Mr. Sajan Puvaya. Like, how do you use?
Two extreme ends of the pendulum questions. I must confess, as a lawyer and otherwise, but more so as a lawyer, I think technology has completely transformed my life. And therefore, maybe in under 1 minute, I've realized that there are 4 phases now when it comes to artificial intelligence itself. The emergence was from 2010 to 2025, the first 15 years. Now researchers indicate, and in fact all the Western researchers indicate that there are 3 more phases for AI. The emergence phase has occurred. We have finished 25. The augmentation phase is between 2025 and the next 15 years. That's 2030. And thereafter, the transformative phase is between 2030 and 2045. And the phase beyond, which will actually, transform everything else, is beyond that 2045. So I don't know how many of us will be in the profession by then. But we have only scratched, I think, the surface when it comes to AI. Today, most of our usages as lawyers, for one, many chambers like mine have gone completely paperless to the sense that it's 100% paperless, with a vow that when you join, you say that you will not touch paper. Second, all tools that are available for augmenting a lawyer are basically very, very peripheral tools today. Now, the augmentation that occurs in the next 15 years will be a scenario such as this. Let me just take one illustration. You don't need to draft your petitions anymore once the augmentation phase occurs. In fact, as you are debating and having a client conference, your petition will get drafted. You don't need to then verify it in terms of whether your lists are correct, etc., because large language modules will have it verified. The drafts will not be based on templates, but will be based on real-time applications that are occurring in courts. And I'm talking of the next 15 years. So no sooner your petition is ready, the only role of a lawyer would actually to bring in the strategy into it and not really the augmentation of documentation. The next phase really is that I think lawyers, and more so as counsel, we will lose our role as people of just poise and narrative. We will actually be the strategic player in terms of bringing the points of law. Second, the difference I think in our scenario will be that when we joined the profession, we prided large chambers which had the best law libraries, and it's the law library which defined a lawyer. But in the augmentation phase, post that when it is transformative, I can only say every senior advocate will actually have a signature-driven AI model actually assisting that chamber, and not a law library. What will that model do? And I'm not soothsaying, and that's exactly what will happen. As my friend Buddy is arguing against me in court, my model will identify for me then and there in court on what the loopholes of his arguments are and what actually precedents support me. As the judge asks those 4 questions to my opponent lawyer, my large language module will demonstrate what's the right answer to it and whether my competitor is faulting over it. And believe me, and sir, this is something that comes up your alley. As the judge begins dictation of the order, of course not in the Supreme Court, because from Supreme Court the only appeal is to Tirupati Balaji in Tirupati, but in every other court, as what else? I need to go to that Lord and pray. But in every other court, when a judge begins to dictate the order, the AI modules that a counsel will have will generate your appeal. And I'm not saying that's not going to happen. It is going to happen in our lifetime as lawyers. So what that leads to for a younger lawyer today is, and that's something that drills into my head every morning, please don't think AI is a tool that makes your life easy. It's not. And Justice Deepankar Datta is absolutely right. AI is a tool that will actually burn you. It's not safe usage. It's not misuse of AI which will trouble you. It is irresponsible usage of AI that will trouble you. So consequently, if you ask me whether AI is going to replace lawyers, I've always maintained this fact. AI is not going to replace lawyers in this country, but lawyers who use AI will replace those who don't.
Thank you, sir. Now, to Mr. Bari Ranganathan, as an opponent lawyer, what would you shoot?
Well, let me respond to, as we say in court, my learned friend's points. But I have a distinctly different experience with AI, because the first couple of times that I used it, I turned up with fake judgments which don't exist. Interestingly enough, this is a problem that has not just been encountered here, it's been encountered all over the world. We have had situations in England where the Court of Appeal has actually imposed costs on lawyers. They have reported lawyers to the Bar Council. A New York attorney was also reported to the Bar Council for having fake citations in his submissions. Very recently, our own homegrown AI, Bar and Bench, just reported about the Dubai International Commercial Court having imposed costs on a lawyer for having submissions with fake citations in it. So I'm not sure where AI is going to go, but I can tell you that right now, I'm afraid to use it. Thank you.
Thank you. So now,
So the first thing I'll say is I think some of those problems of hallucination and so on, it seems very, obvious or maybe natural that those could be controlled by controlling the data set which the software is using. And I think, recently scrolling through something or the other, I saw that SEC Online is combining, their data set with Harvey and so on. So that's one. Secondly, to answer your question, which was a really good question, I started running about 6-8 months ago. One, I used ChatGPT to help me analyze my, running metrics, whatever my smartwatch was picking up, to use that to analyze it. But even more interestingly, I practice yoga very seriously. For some who don't know, Navteej Johar from the 377 Matter was actually my yoga teacher. And he's a very serious yoga teacher. And one of the texts that we use in our practice is the Vigyan Bhairav Tantra, which is a conversation between Shiv and Parvati, in which Shiv then gives 112 meditations, which the idea is that of those 112, any one will suit. You'll find one that suits you, and that will be then your meditation on Bhairav. So I asked ChatGPT, how can I combine Vigyan Bhairav Tantra with running? And of course, I could sit and think about it myself, choose a meditation, and then create that model for myself. But ChatGPT did it. It said, well, this is how you run. This is your current data. This is the meditation that I would suggest for you to combine with your current progress in running. And then I asked ChatGPT, have you used a source for this? And it said, no, I have used available data on running, your metrics on running, and whatever I have read about Vigyan Bhairav Tantra. So what I think is that this is the future. You have to learn how to use it. As many professions, aspects of the profession, we've seen that, for example, photocopiers today, I'm sure many of us have had conversations with our own photocopiers saying that they're having to close down their business. Because now sets are, where earlier we would say, acha 12 set banane hain. Now you don't need, maybe you need a single set or a few sets. Clerks, we know that earlier you needed at least, let's say if you were operating in 4 courts, or even in a single court, every court you needed at least one clerk to carry the bag, make sure that jo filein gayi, they have come back and so on. Today, 1 or maybe 2 clerks, I mean the numbers have really reduced because your entire file is here, your entire office is here on this tab. So I think for us also as lawyers, adapting, because the potential is huge. As Sajan said, we are only at the end of the first phase. And it is a question of, at this age, where, I can say I am a mid-career professional, of adapting and learning. And for young people who are coming into the profession, this is their native world. This is today's Gen Z or whatever, whatever generation this is now. They have grown up as native social media users. Right? They are already immersed in that world. For those who have teenagers, I think they know that regulation is the only way. Elimination is hardly a way. And AI is going to be the same. So for young people who are coming in, this is their native world. They are already using it to draft. They are already using, some people are already using it to combine meditation with their running. And so how do we as a profession now integrate this going forward is, I think, the only question of debate. Elimination is not really a question.
yes, thank you. So I have a question. Yes.
Sajan, you said that as soon as the judge starts dictating, the module will predict what would be your grounds of appeal. Do you mean to say that as soon as the judge starts dictating, it will be able to assess which way the decision is going?
Yes, sir, and I think a very incisive question. The large language modules today are researching, and these are tools, sir, that are now in the next 15 years that's going to come. We don't have those tools now. But the large language modules today which are being researched are not just about demonstrating as to assimilating the data that is available to generate a draft appeal. The large language modules today are also learning the methodology of a particular judge as to the previous decisions he has rendered in a similar matrix. And therefore, sometimes, not even when he's dictating, even before you file your matter, there is an analysis that is made by the module of saying, will you get an interim order in this matter before this court, or will it only be a final relief? Based on which, do you want to take senior advocates for an interim hearing and lose money, or do you want to simply get notice and come back for a final hearing? That's one. Second, that model developed to the next regime, that is by the time we are in 2030, will demonstrate to you when the dictation starts based on the language that is used in the first few paragraphs, on whether this judge is going to give you a positive or a negative order. Now, what changes this? And therefore, I keep telling younger lawyers that you will never be replaced. What will change that narrative is the lawyer's narrative in court during that dictation, which may or may not change a judge's mind. Barring that, the tool, I dare say, sir, the tool will be exactly precise on whether you will win or lose a matter, possibly not today, in the next 15 years. Not immediately in all courts of the country, but possibly in certain courts, in certain metropolitan courts, possibly in certain high courts. The databases are being built. The one difference is this. Google, for example, for all lawyers who use Google, which is everybody, 97.9% of the world today uses Google. Every time you are actually searching for something on Google or actually uploading your document onto a Google Drive, the Google Notebook LM today is actually a beta version, is learning out of it on what a particular court is doing. I'll give you one illustration, sir. Today, in a beta version, I can take a brief which is being filed by my friend, put it into the Notebook LM module, and tell the module that give me for and again arguments, not in terms of a write-up, but as if it is a podcast. It will, in the voice of the two lawyers, tell me what will be the arguments that Buddy Ranganathan will have against me and what should be my answer. And I have tried it sometimes. It is exactly what happens in court today. And I know I'm losing even before I go into court to Buddy.
So I asked Justice Datta to respond to this.
Let me tell you, I believe I'm the only judge in this audience.
Yes, sir.
It has happened to me twice. I have dictated an order in open court. The order was transcribed, placed before me for my signature. Before I sign my orders, I again go through the file, and I found that I had made a terrible mistake. I did not sign the order because the Supreme Court judgments say, so long as you don't sign an order, you can put it back on board, hear both the parties, and you can even go to the extent of changing your decision. And I have done that twice. So what does AI do about this?
Sir, one word.
Yes.
Sir, judges like you are very difficult subject for AI, sir.
But sir, I'll say one thing.
Yes.
That kind of software, because while we were preparing for this panel, I read up on it also. So Lex Machina, something called, I think either predictability or something in the US, they are already doing this using data sets down to the district level. They are able to, they say, predict. Now, what you're saying is something different, but they are able to predict. But the other thing I'll point out is just at a, human level, sometimes when we read judgments, we read the first few paras, and we have a sense, yes, from the language which is used, from what the facts which are prioritized, we have a sense what they are doing in the end. Even when sometimes the actual relief which is given and the ratio which is laid down may be at odds with each other. But reading the first few paras, sometimes just how that is set out, one gets an idea of what the rest of the judgment will do. But this software which Sajan is talking about is already available for commercial use in the US.
Can I just add one small point? Am I too big for this? That's the difficulty with AI today, at least. if that software is going to give you a draft appeal while the judgment is being dictated, the problem that we are facing with AI today is its philosophy. It aims to please. It wants to give you what you want. The question is it going to give you an opinion that you don't need to file an opinion that the judgment is correct? That's the question.
Buddy, but haven't you, before your designation, sometimes prepared the appeal even before the judgment has come?
Fortunately,
I mean,
no.
no, but we've...
No. I case.
My practice days, it so happened that we knew that this particular judge would not pass an interim order.
Yes.
So along with filing the petition, we had our memo of appeal and argued it in such a way so that the division bench, which is more liberal-minded, we did it.
Sir, Buddy is known in Delhi to first draft the appeal and then draft the suit.
On the presumption that I lose the suit.
To move on.
He says is very serious. I think this will discourage judges from dictating orders in office.
Yes, indeed. Correct.
Better to reserve judgment.
Like, coming to that point,
So sorry, but just that, sir. Even if you reserve judgment and one of your law clerks uploads your draft judgment onto a chat GPT, the chat GPT is actually learning from it. So if I, as one of the counsel there, want to draft an appeal and I ask chat GPT to produce an appeal for me, they already know your judgment before you're signing it.
Why should it be there?
Because if,
First place, before we sign the judgment, pronounce and sign,
correct.
it will not come in the public domain.
So, but once you upload it on chat GPT, yeah, once you upload it on chat GPT, the whole world knows that this is what you've dictated.
If your law clerk is working on ChatGPT,
Acha.
then already that material is published. So if you're checking the English and the grammar, it is already there in the cloud.
And
Thanks, sir.
Thank God, I'll have to endure this for another 4 years.
yes. Ma'am, we can have a question and answers.
this is the fairness, Alvar.
Thank you. Sorry, I have to say in favor of AI because I'm from data analytics and AI. Yeah. And I'm director in a consulting company, and I work. This is my profession. I do AI and innovation everywhere. So all the problems can be solved if Supreme Court has its own enterprise version of ChatGPT. Then the data won't be shared, and yeah, then the whole problem solves. and the second trick question answer is when you ask a question to AI, say be ruthless, be cruel, don't give me anything which I don't need, and don't please me, and then it will be very brutal to you.
Thank you, Rolly, ma'am. Now to move on. To counter this point, I asked Buddy Ranganathan, sir, like AI has a lot of algorithmic bias, ethical risk to rely upon the data. Because unless the human perceive something in front of me, like today I have a judgment. If I have a copy, I know which judge has wrote and where I downloaded it. And now the problem with the AI, it just uses the data and analyzes and give to you. There are some instances, it end up in fake judgments being generated. I had an instance, I had to draft a petition very urgently. So I'm stupid enough to rely on AI. So I uploaded the judgment and it gave a completely wrong findings of the judge. Then I have to spend 2 weeks on my time to read all the 10 volumes. Then I have to draft the SLP criminal. So it is completely contrast effects we have. So we cannot completely rely on, we don't know. Is that like, as AI has a black box, we don't know how to rely upon this. Do you have any suggestion on this?
The suggestion is very simple. Stick to what you were always doing. Read your brief. Don't look for shortcuts. Use AI as a tool, not as something which is going to control what you're going to do.
Exactly.
So, in fact, this is exactly, there's a very interesting article where all these large language modules, which are the basis of even AI search engines which are now being introduced by Thomson Reuters, by LexisNexis, who are also, and there's a very interesting article, I don't know how far true it is, but this article has analyzed that even the specialized databases, which are called RGMs, of Thomson Reuters, LexisNexis, Butterworth, etc., are giving wrong results from anything between 16% to 33% of the time. There are situations where AI has generated an analysis of a judgment where the arguments of the counsel are being treated as the finding of the judge. And there is no way of knowing unless you actually open the judgment, read it, analyze it yourself, understand it yourself rather than relying on AI to understand it. So as of today, that foundational obligation is yours. If you are drafting a petition, it's going under your signature, you're standing up as a counsel and arguing it in court, you're responsible for what's there. You can't take the shield of saying that I relied on AI generated this for me and I put it there. So bottom line, stick your backside to a chair, sit and read.
Yes. Now to move on, so I'd like to ask Mr. Sajan Puvia, sir, what are the safe and trusted AI tools which we can rely upon in today's time?
I'm glad you asked the question. In today's, and this actually very timely, it takes from where Buddy has left it. Do AI tools of the day have their problems? Answer is absolutely yes. Is there a trusted AI tool today? Answer is an emphatic no. And that's not because AI is the problem, that's because we are in a transformative phase where machine learning is still augmenting itself. And that's why the second phase of augmentation comes in. There is a non-availability of big data when it comes to the judicial matrix in this country, or for that matter in the world. Second, quantum computing and computation technology increases such that actually the analysis will take some time. We have still not reached a quantum computing where big data analysis happens in a few months. It takes a few years. And therefore, the tools will learn themselves to an efficacy rate where your failure rate will be 0.0001%. 1 in a millionth case will be the failure rate of an AI tool soon in the next 15 years. And therefore, these questions which we face today, which are existential questions on can we use the tool or not, will vanish 15 years down the line. It's as we asked ourselves a question, I'm sure Justice Deepankar Datta will remember, TCP/IP account and emails being downloaded on a TCP/IP account in early 90s. That's what we did. Telephone dial into a modem, convert analog to digital and get a TCP/IP mail, which was gibberish, which would all be, scrambled and we couldn't read. To today's communication levels, does anybody not trust an email today? Particularly in the light of the Information Technology Act. That's exactly what's going to happen to an AI tool. But the difference is that we can't find that tool to substitute our profession. That's not, it can only be used as an augmentation. And therefore the question is not, is there a reliable AI tool today? The question is, will we have augmentation with artificial intelligence which will take our profession to the next level? Answer is yes. I'll leave with one example. Are driverless cars today the norm? Answer is no. But in 15 years, will they be the norm? Answer is yes. What happens in it if two driverless cars collide and somebody actually dies? Do we have to file an MACT claim? Answer is no. Because the Internet of Things, both are communicating. Both cars know what's the damage between the cars, how many humans have suffered injury, and they are connected in technology to the last mile of whose liability it is. And therefore, the minute there is a crash, there is also a liability memo coming up saying that who pays who. You possibly don't even go to court then. So that's the transformation of technology we're facing. What are we looking at being in court and litigating that? So that's what's happening to AI as well as we speak.
I would like to go to Justice Datta.
Taking a cue from both of them, I am reminded of a story. You must have heard it. There's a story of a king and a monkey. So whenever the king sat, the monkey came, he hit the monkey on the head. Continuously it went on happening. Then the mantri asked, Raja, what is this? Why do you hit this poor monkey? Well, very well. I'll show you why I hit this monkey. So next day, monkey comes. He doesn't get a pat on the head. He sits on the knee. Next day, he sits on the shoulder. And the third day, he sits on the head. And then he again slaps him. He goes down to the feet. So AI should be kept at our feet.
To move on with this, I asked Ms. Arundhati ma'am, like now Sajan sir told us what are the safe and trusted AI which we can rely upon. Like how do you adopt the current generation of lawyers? How do you adopt the AI integration into a field?
So I think to some extent it's already there, right? Like when you look at something like Indian Qanun, even liquid text, like which, if, I think like it's probably on all your laptops here, right? They have AI prompts. The problem is today they are still very clunky. I mean, liquid text lets you do something like all the definitions can be cross-linked within a document and so on. I've tried out some of those things. They're still very clunky. They're often inaccurate. But I think what's going to happen going forward is that the person who gives the right prompt, who asks the right question, who gives the right point for analysis is going to be the lawyer who's the better lawyer. In a way, that has always been the case. Okay, like I remember when I graduated from law school, SEC Online had just come in. There were specific, DLT had a software which was Delhi specific, which was excellent for local laws and those kind of issues. And it was all looked at with great suspicion by our seniors. They all had, with all respect to all my seniors here, but they all had their registers with the research that they had accumulated over the generations. We had our libraries, which had all our compendiums, the annual digests on specific subjects, specific courts. Today, I don't even buy those anymore. I mean, I don't even refresh my library with those because frankly, my colleagues are not using them anymore. I mean, we are barely using the commentaries which are there in the libraries that we have. So what I think is going to happen is that even at that stage, when we started using SCC, the better lawyer was the person who knew what question to ask, how to frame the question. I mean, today, Monday, Friday practice is exactly this, that in that 1 minute, in those 30 seconds, how do you frame the issue which is before the court? The mechanics of it will be done by, I mean, today maybe your colleagues are, or we are putting together those drafts, those first drafts, and the refining is done at a senior level. Tomorrow, perhaps those first drafts are going to be done by a machine, but the better lawyer is going to be the one who knows how to frame the issue, how to frame the question, how to frame the matter which is going forward. And perhaps the difference is going to be that while today it's experience of having been in a particular court, our seniors always used to tell us, law is not learnt in the corridor or the canteen. Go in court, even if your matter is not there, watch the judge. Watch what's happening. Sometimes, I won't reveal my own tricks of the trade. But the point is, to some extent, that is going to be replaced by machines which will already have a certain analysis of Justice Dipankar Datta in the last 52 Mondays and Fridays has done this, this, and this. And this is what you can predict. But still, your input is going to be your understanding of the issue and how to frame the issue and put it forward.
Thank you. Now, I asked Justice Datta, like today the Supreme Court of India using two softwares, one for translation and one for legal research. And what is your comment on that? And do we have any other suggestions to have a transformative change? Like, can we have some other software which can, like, because we have a length of pleadings being filed, like thousands of pages, because it takes a lot of judicial time to go about this.
Here, these are in-house tools which have been performing quite well. So far as the translation tool is concerned, more than 1 lakh judgments have translated, and we have not had any complaint that this has been deficient on any count. But what I feel is, something needs to be developed in the Supreme Court, and I'm sure the appropriate committee is up to it. We need for administrative tasks, very simple thing. Registry can't even segregate bail applications, which are regular bail applications and which are filed in 389 appeals. It comes to us as bail applications. Well, the mindset would be absolutely different. When I'm considering a 389, the presumption of innocence doesn't exist, right? Whereas when we are deciding a bail application, considerations would be different. Well, there's a particular committee looking after it. I'm sure they would be finding out.
Thank you. Now to Ms. Arundhati, why not let AI deliver judgments?
Why not let AI deliver
Yes, please.
So I think there's a final balancing act which takes place, right? Which is the human understanding of where to come out on an issue, right? And that's true for us as lawyers. That's true for, I'm sure, on the bench. And ultimately, I mean, I think there's consensus on this panel that it's not that the machine will be left on its own to act, right? Can we keep it at our feet, as Justice Datta said? But you know, it's very interesting. The Kerala High Court has come out with a recommendation for the lower judiciary as to how to use AI, what are the parameters, and that only approved tools can be used. I mean, the other thing is, I'll say that I'm sure we have all seen, I mean, definitely drafts where we can guess that these are produced using some software, perhaps even judgments where we feel that to some extent they have been written by software or augmented by software. So there has to be a human involvement. But you know, you already have digital courts, you already have a certain kind of adoption of technology which has happened. I don't think these things are going to be reversed or ought to be reversed.
Thank you. Now to Mr. Sajjan sir.
If you don't mind, can you just add to that for a moment? Just
Sir, I have a beautiful question for you.
Oh, okay. Like the Kerala High Court has actually said in one of those recommendations that if it is found that a judgment has been delivered through AI, it will be an issue for disciplinary proceedings against the judicial officer. You know, that's the level to be the recommendation of the Kerala High Court.
Yes, thank you. Sajjan sir, like, what is your what is your take on this? Like, why not? Because you're relying on too much on AI. So why not let us use it? Because in China and few other countries, in a minimal level, they have started using AI already. So why not we extend that to India? Because there are a lot of litigations are pending in various courts. So what do you suggest?
Again, I'm not being a soothsayer. This is research material available today as we speak. Should AI tools be delivering judgments? Absolutely not. And I agree completely in what Justice Datta said. Why absolutely not? For two reasons. One, these tools are not evolved as yet, number one. And they really don't have an understanding of community standards coupled with the legal matrices that should be applied. It's not a substitute for a human mind. Second, let's also be clear that constitutionally in our country, I don't think you can have a machine render judgment because it's still a human being who's to be appointed as a judge to retire at a particular time to have a particular qualification, and that's world over. But what we are talking today is exactly what the present discourse says will happen 2060 onwards, which is the futuristic phase of AI. All dispute resolutions which are at a particular threshold, for example, motor accidents or smart contracting, you know, the one word on smart contracting, contracts are not no more going to be on paper where we write something today and then implement it 10 years down the line. Smart contracts are contracts that are evolving every time the machine is used. For example, two driverless cars. As they are being used, the contracts between the two companies are evolving, and therefore in a dispute resolution mechanism, it's an AI tool who actually indicates on a particular accident whose liability it is. And therefore, there will be a private justice delivery system that will evolve 2050, 2060 onwards, which is not going to substitute the public courts, because the paper says that, and I use those words. They say judges of today in 2060 will have only two roles. One is that they will be philosophers of the law, and second, protectors of constitutional values. Therefore, these constitutional claims, etc., can never go into AI. But can a tax claim go into AI? Answer is yes. Will it become a delivery system that there will be justice delivery on AI? Answer is yes. Will it be today? Absolutely not. And therefore, we should realize that some of these questions are really far ahead of time. It is like asking me in 1995 or 96, could I actually have my entire law chambers on a desktop or on a handheld, and lawyers could sit in different jurisdictions and work real time, and their update real time is prompted to me, and I could actually appear in the Supreme Court of India sitting in Burundi, but which is a fact, it's happening today. And therefore it will happen, but I think it's a matter of time, and it's a matter of efficacy of the tool.
Yes, yes, yes.
You know, we have seen an explosion in litigation. 2025 Supreme Court filing was more than 75,000. 2024 it was 63,000. So in 1 year the increase is 12,000. And I'll take 2 minutes, right?
Yes.
Because there are media persons here. They should also know. In 2018, in Supreme Court, the filing was 40,000. The sanction strength was 31. So the judges felt that it's too much for us. 31 can't handle 40. So there was a proposal for increase. The strength increased from 31 to 34 in mid 2019. And in 2019, the filing was 43. We are still at 34, 7 years down the line. 43 has become 75. Does anybody report this? No. Now, it could be possible that down the line, 2050, 60, AI can do it. But now, as of now, Constitution has entrusted this duty on the judiciary. You know, legislative functions are being performed in their own way, executive, I'll not make a comment. But the people have their trust and faith reposed in the judiciary. Now, why is this explosion? You know, I list 4 conditions for this. And I take inspiration from our scriptures. One is hinsa, violence. Second is lobe, greed. Third is calm, lust. And the fourth is krodh. Now, it is we as judges who are human beings sitting on the dais, we are in a position to assess the human elements that go into the litigation. What is the real cause for the litigation? And we have to find out where the justice of the case lies. I do not know whether in future AI will be in a position to do it or not, but for the present, definitely no.
Thank you, Lordship. Now I ask Mr. Bari Ranganathan, like in a motor accident claim, as Sujan sir said, like we can have a help of AI and decide this. How do we analyze the intention? Like why the car is collided with this? What does it lack? Because we know that AI has lacked human empathy. In a criminal jurisprudence, like while sentencing an accused, the judge looks at the accused and see whether he bow down or he looks into the eyes of the judge. That one moment has changed his entire imprisonment. It may go to 3 years to 10 years or 10 years to 3 years. What is the comment on that?
Well, just in a lighter vein, I'm glad I heard Sajan giving his answer right now. Otherwise, I would have suspected that it's probably an AI-generated answer. But be that as it may. Yes, I think there is a serious issue here. And as Justice Datta said and Sajan said just now, as of today, there is no question of any AI tool trying to substitute judicial thinking. There is no substitute for how a judge is going to look at a case, how a judge is going to look at an accused. In fact, I think, I mean, I've never been a judge, Justice Datta will probably correct me, that sentencing is actually a far more difficult process than actually finding guilt or innocence. So sentencing is something for which there's no real guideline in that sense. There's no real benchmark. So much depends on the judge's outlook, so much depends on the judge's view of hearing the case, so much emphasis is on how the accused comes and presents himself in court. So according to me, as I said, AI should be used only as a supportive tool. It is, I mean, for want of a better comparison, a slightly more advanced STC online. Use it like that, you'll do well. Try and make sure that it argues your case for you, you have a problem.
Thank you. And I have a follow-up question with you. like how do we address the copyright infringements and AI-generated contents? Because today the Copyright Act gives a protection because there are many AI-generated contents being used in court of law and even in patent registration, copyright registration. How do we address those infringements?
In fact, that's a serious concern worldwide. And a lot of AI platforms have very, very clearly taken the view, and publicly so, that there is absolutely no question of any data privacy or data protection in this situation at all. If you put something on a chat GPT, you've completely lost whatever data protection you wanted to preserve. That's why if you're talking about Justice Datta saying that if a law clerk just puts a judgment on chat GPT, the whole world has access to it. There is absolutely no question of any copyright protection. There is absolutely no question of any data privacy or protection at all. So that's a choice you make.
To Ms. Arundhati, what are the harms of AI and the measures to mitigate the algorithmic bias and ensure transparency?
Yeah, I think, this has been seen with the use of tech everywhere, that the biases that we have as human beings are reflected in the algorithm. Okay, so it's like broken windows policing, which was adopted in the US, for instance. And I think at its heart, it's this, right? That, sometimes as lawyers, we tend to see things in terms of like mathematics, okay? You have an MSCT case, this is what your claim is roughly going to work out to be, and if I achieve that, that's a good outcome. This is the offense, this is the heinousness. I have an idea that this is the kind of sentence which is given. If I can come below that, that's a good outcome. Or in matrimonial cases, okay? Sometimes we think, why don't parties settle? This is a kind of fair range of maintenance, alimony, etc. And what are you hearing from the other side, from the petitioners? I want justice through the system. I mean, they are framing their understanding of what is happening to them in terms of justice. And the question is, can that be delegated? Definitely not. I mean, I think that we have to remind ourselves that that is actually the essence of the system. When we call these systems the criminal justice system, it's actually the word justice which is at the heart of it. And for persons who are going through that process, I mean, who are really suffering even through that process, through the time it takes through those processes, what holds them to it is the idea of justice, that this system is supposed to deliver justice to me. And that's something which can't be substituted by an algorithmic sense that, let's say, 1,000 rupees or 10,000 or a lakh is a good outcome in this matter. So that's where the human element is really at its core and can never be replaced.
I put the same question to Mr. Sajjan.
I think Selvin's questions, your questions are deep. The problem is, you see, the minute you talk of algorithmic bias, you get into a different domain altogether. That's not the problem with AI. That's the problem with the edifice on which AI is built, that is machine learning. Now, there are researchers as we speak who are actually researching their doctoral thesis on subjects such as algorithms, artificial intelligence, algorithms, and caste biases in the law in India, not racial bias. Racial bias, there's quite a bit written in the US, for example, on the same AI tool will give you a different answer if you are black, and if you a different answer if the accused is white. Those biases exist. But just imagine in the Indian context, it's not racial bias, it's caste bias. Should the AI tool give you a different answer because I am a Kodava or somebody else is a Brahmin? Now, those are problems in the methodology on which an AI tool is built today. It's not a methodology problem with computing, it's the methodology problem with the data sets that are available for the machine to learn. But you can't find fault, you don't shoot the messenger, you can't find fault with AI as a tool that is available for augmenting our skill sets and say, oh, there are biases. There are biases everywhere. You don't cut off your head because you have a headache, and that's the problem with that AI tool and bias. Second, the problem today is again not with the tool or technology, it's with the regulation of that technology. Unfortunately, law in India always is 7 steps behind technology. Please look at a scenario. I think there is a need for a law today, and we have some parliamentarians as well here. So there is a need for a law today, before the tools actually become robust. If a lawyer has used an AI tool to assist in the drafting, there must be a mandate from court saying that you will disclose it in the petition. You will have to say that I've used the following tools for drafting. Because that disclosure brings about fairness, it brings about transparency, and it brings about a tool for counter-checking those biases. Unless you know that a tool has been used, how will you counter-check? And today, it's regulatory vacuum. I can completely use, based on my technological prowess, I can completely use an AI tool today to draft a petition, completely analyze Justice Datta's judgments over the last 2 years, and possibly get a notice and stay. Without a disclosure saying that
Maybe
it's
not.
I don't think it's going to be that
dismissal.
easy.
Maybe not anymore.
No, yeah. Arundhati, at least outside court, let me get a stay from his court.
You'll be noticed and you'll be asked to stay back. So, I mean,
Sir.
Both sides use separate tools
Yes, sir.
and come to differing outcomes.
Yes, sir.
Can it happen?
It can, sir. And that is because these tools today are actually only in their very, and that's the difference, the very nascent stage of their development. When we reach that stage of 20, 30 plus, these tools would have received a level of perfection that these tools will not be distinguished between a right and wrong answer. Both answers will be the same, but they will be distinguished from the sharpness of that answer. And therefore, you may use a particular tool for the legal matrix because the answers are sharper. But all tools will give you the same answer. And that's the benefit of
Today you run the risk of assessing the judge wrongly.
completely, sir. And therefore, we should not use it. The younger generation, the only piece of advice I can give, today to use a tool, okay, let me put it this way. You're trying, by using an AI tool today to help you in actually drafting an appeal before the Supreme Court or do research for a point of law before the Supreme Court, is akin to, in the 1920s, using an internal combustion engine to run possibly a Formula One race. You can't do that. And you know that you can't do that today. You don't run an IC, 30cc engine to run a Formula race. Why? Because technology has improved today and you know where the thresholds are. We don't have the tools. Second, we don't have the regulatory matrix for responsible use of those tools. It's only after the regulatory matrix comes in can you use it. Third, and most importantly, is when it comes to building technology, we have to remember that our technology is only as good as the metadata and the big data sets that are available. We do not have, although we have a national judicial grid today, we do not have the efficacy of that data verified as yet. So it is that unverified data which is feeding the tool to learn. And why are you blaming the tool? It's learning from what it is given. You don't nurture a child well, the child will turn out to be a bad child, although born to a good family. And that's the problem with AI tools today.
Like I asked Mr. Badirangadan, in that scenario, who do we make it responsible? The developer or the user?
well, I think, frankly, who is responsible is a lot more difficult to answer. But whose obligation is it to make sure that what you do is the right thing? I think there is no doubt about it. It's the user. It's the user who is obliged to make sure that the results that he's wanting to use from AI are verified. The obligation is of the user to see that whatever results he's getting are actually sustained by the real data, are actually sustained by the real judgment.
Thank you. To Justice.
We are car fanatics,
Yes, sir.
right? So we purchase an expensive car and then crash it.
Drive it badly.
Drive it badly. It's not the car's fault. It's our fault.
Completely correct.
Just to move on. So I asked Justice Datta, how artificial intelligence affects decision-making process in life and in court?
Personally speaking, it doesn't affect me at all. Because we have learned the hard way. You know, if we go back to our practice days, when I joined in 1989, Mr. Gupta was there in the Calcutta bar. You know, we had a different sort of grooming. And our grooming was again different from the grooming that my late father had in the 1940s. I heard that his senior asked him to sit on a tool for 1 year without touching a brief, without touching a book. What is the purpose? Purpose first testing the patience, whether you have the patience to survive in this profession or not. Now, 40 years down the line, our seniors were quite kind and generous. Yes, you can look into briefs, you can participate in conferences, maintain silence. Whatever questions you have, you ask me later on. For research, what we had, SCC Digest, AIR manual, and annotated books. Now, my son graduated about 2 years back. He was in his final year. I gave him a topic for research. He brought me a whole lot of things. Where did you get it? He told me, you wanted it, I have given it to you. Don't ask this.
Typically A answer.
So you
They are,
would never,
present, they are present generation lawyers.
so you would never have got that answer in court. You'll only get it at home.
So, you know, it's a pleasure reading hard copies. So therefore, it really doesn't affect me personally.
Yes, Arundhati ma'am.
You know, but on another level, I mean, this issue of deepfakes, for instance, right? Entire elections have been swung by the kind of imagery that you can create about ex-politicians. Well, I mean, just this morning or yesterday, I was reading that there was some picture of Donald Trump attending the Kumbh Mela. You know? So, I mean, entire elections can be swung based on wrong...
attend to Kumbh Mela?
Ajahn, we'll talk after this panel.
Last
But, yeah. So the kind of impression that it can create and the belief that you can have in what you're seeing is sometimes indelible.
Just one immediate thing to just take it forward. And that's exactly the problem, not just with AI, but the problem with actually, again, when we talk of AI, we are lawyers. Of course, we have some technical people here. We have to make a distinction between Gen AI, that is generative AI, and AI which is used as a tool for actually augmentation. For example, chronology building. I'll use that. Chronology building is something that lawyers use. We need a list of dates before we start. Junior would actually sit down and look at thousands of sheets of paper to build a list of dates. Today you have fairly competent tools for chronology building. They are non-generative AIs, which look at the data and build a sequence of dates. We are fairly accurate. I think on that tool, we have reached a particular level of sophistication. As compared to generative AI, which generates data, which is deepfakes. And that's the problem with your two decisions of X versus Y, Sajan Puvaya versus Raja, which never existed, but generative AI generates that particular case. Gen AI is still in a very, very nascent form, both in terms of development and more in terms of regulation. The answer to deepfakes, and particularly deepfakes in the law, for example, this Supreme Court of India decision which does not exist, is not technology. Is regulation to say you will watermark a Gen AI content. Any content generated through AI will be watermarked as Gen content. Therefore, I must disclose that this is a product of a generative AI tool. The minute that is done, a judge looking at it knows that this is Gen AI, and therefore the opponent knows it's Gen AI, and then he cross-verifies. That trust-building mechanism, which you pointed out in the previous scenario, exactly happens because there is a regulatory oversight for disclosure. And that's what we should build. Not kill the tool, it actually benefits man. But build ecosystems for that tool to thrive in a particular manner.
But I'm just going to respond to what Sajan said on this issue of list of dates. Okay, so list of dates is one of my pet peeves in my own office. Because even an auto-generated list of dates, right, you can create a list of dates. What is a good list of dates? A good list of dates is one which has analyzed the matter. You've thought about what are you going to argue in the matter. When you stand up in court, what is going to be argued? And those points are reflected in the list of dates.
Notebook
so all
LM.
lists of dates are not
Notebook
equal.
LM. Use Notebook LM, it will do this for you.
But you know, this is actually...
Yes.
Correct it once or twice, it'll understand how Arundhati would want a list of
Yes.
and the third draft will be brilliant.
But you know, this has actually happened. I have received a list of dates from a briefing advocate. And when I went through it, every description of every single one of the documents actually supported the other side. I was, I was aghast, you know. I mean,
So there's one line on this. You know, Buddy always finds fault with artificial intelligence. Artificial intelligence are for those people who are not really intelligent. So therefore, you don't need it, we need it.
Thanks for the admission. Yes. So to move on, so I put it to Ms. Arundhati, like, to what extent can we use AI and where to stop?
So I think, I've already told you how I've used AI. And I think the thing is that you still have to do the running. You still have to do the meditation. You know, the tool can give you this wow model, which, you still have to ask it the question to give it that prompt of, well, can I combine these two loves, But actually experiencing it is what makes us human, right? And that cannot be substituted.
Yes. So you said you're using AI to help you in yoga. Has it ever misguided you in a wrong yoga pose?
No, you see, of course, like I have to have that, today um, I have a teacher who is outside of the app, right? I have a life which is outside of the app. But is the app able to, actually what it did was it eliminated the work which I would have had to do. So I thought of something that could be put together. I thought of how I wanted to put it together, which is, can I use this thing which I do in yoga while I'm running? But it just instantly created the model. Now, can it misguide you? Yes, but if my question is wrong, if my attempt to use it is wrong or somewhere malintentioned, then 100% that can happen. But ultimately, I have to experience the answer that I'm seeking also. Without that, I mean, it is ultimately the human experience. It is how we use what we get to change or to adapt or to grow.
Is to move on. So I asked Mr. Ranganathan, does it affect my mental health, the cognitive decline, like critical thinking, the creativity of the human being?
Well, I don't think it has till now, fortunately. But believe you me, today, what you are as a professional is a product of your learning and experience. That learning and experience has come from whatever work you've done. If today you're going to start using AI to substitute that work, then the decline is going to start. That's for sure.
Yes, to move on to Mr. Sajjan.
Where to stop?
Yes, and please, enlighten us.
You know, this is the sanctorium of justice, the court halls. When a lawyer comes and argues, judges always trust the lawyers. But this trust is very fragile. Once this trust breaks, next time onwards, court will always view with suspicion. So therefore, it is upon the individual lawyer to decide, because he would be knowing what he is submitting before the court. He would not be knowing that. So this is an onerous duty on the lawyers that is cast on them to not mislead the court. Where to stop? You know where to stop.
Thank you. To Mr. Sajjan, sir, the last question of the session. How the AI will lead us in the future? Like after 50 years down the line?
If somebody had asked this question in the 1960s on how computing technology is going to change human lives, and the technology philosophers of the day, when they indicated in the 60s that you will actually have a handheld apparatus in which you can see people worldwide, transact with them worldwide, or people of today indicating that we could be present in two places at the same time with our holograms doing exactly what we do, is still a futuristic idea. Or an Internet of Things as we speak. Self-driven cars is nothing but a formulation of Internet of Things on the road. Now, Internet of Things itself 10 years ago was a idea which was draconian, but it is put in place. So will artificial intelligence become mainstream? I have no doubts in my head. If all goes well, I believe that in the next 30, 40 years at least, most of us should be available in the next 30-year horizon. Technology will actually, AI will become mainstay. But the problem is not on whether it will or it will not, or should we use, should we not use. The problem is that I don't think our generation and the younger generation identify where to stop the human interface with AI. And that stopping comes, for example, no technology can give you a substitute, as we speak today, for your narrative persuasion in court of a judge. There is no AI tool for it. Second, You can never have an AI tool which will give you the intuitive analysis of a court proceedings as it is going on. That intuitive analysis is that of the human mind. That's what keeps a lawyer, sets him apart or sets her apart. Third and most important fact to the younger generation is, no AI tool will give you the moral courage to stand up and argue an unpopular case. There is no AI tool for that. That is the essence of lawyering. That's the essence of courtroom lawyering. That is the essence of advocacy in our country. As Justice Datta said, that's what our seniors kind of percolated to us, saying that you will stand up and say what it is, irrespective of what people think of you. There is no AI tool for that. So let's not clamor ourselves to say that AI is the end-all and be-all. I'm only saying that if you are inherently good, AI will make you better. If you are bad, AI will make you worse. But that situation is, but AI is an indispensable tool in our lives. As much as an email is today, AI will be possibly 10 years down the line or 15 years down the line.
Mr. Ranganathan, would you like to?
Oh, well, I hope I can agree with Sajan. That's really the bottom line of how I would look at it. And yes, I agree that if it's a tool, please use it as a tool, and please know where to stop. That's the bottom line.
Yes, thank you. Now let's have a few questions and answers. Starting with, yes, Ms. Yes, please, begin.
Okay. Yeah, so that was a great discussion, and I'm back. And so we work with the different banking firms and NBFC and everybody talks to us and they always ask, like, what we can do for you. And they always say that we want you to do AI governance. That's the most important, and data structuring. So AI governance leads us by, okay, as a technology company, as a consulting company, we can do so much, but a lot of governance boils down to conflict resolution, advisory, which again comes to what are the policy and protocols and how the courts are functioning in preventing it. So all the banking firms, all the financial institutions in our company are looking forward to government and courts to, ramp up, like seriously get the knowledge up to a degree that they can support us in return. And that goes for all the other institutions as well. Financial, most important because it is backbone of the organization, of the country. And the second is, so what is the judiciary doing towards it? Like we need, okay, government must be creating certain policy, but judiciary also needs to step up. So how we can, as a consultant, tell the organization, okay, this is happening, it's coming our way. And also in all the budget sessions, which is also going to come on 1st of Feb, and in the last one, it has been prominently said that India is working towards data set creation, large for running LLMs ourselves. So are we thinking of creating a huge data sets, like a large amount of for judiciary as well? Because we are discussing about how to use AI, but what are we doing to better work towards it or deal with it better? And how, as outside, we can support in it? It's a heavy loaded question. You can choose anyone or anyone can answer. I know I asked all the questions which I had.
Do we want to take some questions from the audience?
Okay, so I'll put the background, the con. Okay, sure, thanks. So a bit of a background and then I'll come to the question. See, we all agree now after this discussion that AI is assistive, but at the same time, human intervention is inevitable. And that's how it's going to be for a while at least. Now, I run a small law firm, and what I see is an issue that AI is giving such good assistance to lawyers, somebody who's running a firm, that juniors are not really able to match up to the kind of assistance AI is providing. In that case, we all started our professions under somebody's mentorship, and we basically did the basics of research and analysis and list of dates. Now, we will have AI doing that. So there's a major issue which I feel could be that how will the younger people who are graduating from law schools, how will they hone their skills? How will they learn when people will start using AI to do their tasks? Where will they learn? And what sort of competency would be expected from them to be able to actually, become lawyers of some reckoning? So this is an issue that for the first 5 years of your profession, you would face among the younger generation, because the people who are coming to our firm, I can get the same answers through AI, and it reduces the time. What would take me 1 hour, I can do it in 10 minutes. I don't need them. I get my assistants, I create my leads, I put it on Google, find the case laws, do a bit of research, and I have my answer. I can give my opinion. So that's the question.
No, this is not a question. What I just wanted to indicate was that we are still talking about where to stop. The next 2 generations of AI, one is reasoning and the other is action. Once you reach the action stage, it will not be in your hands to stop. It will decide whether to stop or not to stop. That's the last stage, action, where action will be taken through AI. But even in the reasoning stage, anything that the human mind is capable of will be learnt by the machine. And this will not only be data, it will not only be solutions, but it will be also ethics. And already, at least the European Union has already developed ethical models to teach machines that these are the ethical rules that the machine must follow. That takes care of deep fake. One of the ethical rules is that you will not feed what you know is incorrect, etc., etc. So we are still talking about using it as a tool. Using it as a tool is a very basic level of AI.
I just wanted to make one quick comment because I wanted to invite the panel's attention to this detail, sir. A lot of discussion was very illuminating. I thank the panel, but I think a lot of discussion was focused on the adjudicatory aspect and the lawyering aspect of it. Sir, I am someone who is an evangelist for AI because I think it's a great enabler. In terms of actually rendering justice outside the adjudicatory forum, sir, if the AI tools are going to be used, what may happen is at many, many levels, matters may not have to come for adjudication. Not in the smart technology that Sajjan was talking about, but if the contracts, today what happens is if somebody wants to draft a will, they just have to go to some lawyer. I think the Union Law Ministry is now coming up with some mechanism where they want to use Bhashini and something which will be giving proper advice to people on several legal aspects. So if the justice delivery and in terms of legal knowledge delivery is going to happen better using AI, then possibly we may have better contracts, we may have lesser conflicts and lesser need for adjudication. And I think what Sajjan also was mentioning about the necessity of having watermarking. So in fact, there are some draft rules that have been circulated. There are a lot of pushbacks because a lot of content creators are having a problem saying that this is going to be creating a problem. But I think, sir, this one area where I think central government has been quite active in terms of making dynamic rule making, but technology presents its own problems.
Hi, sir. So I'm from the school of thought of Mr. Pavaya, and I agree with both of you what you are saying. We run a law firm. So last year we did not have to hire any lawyers. We hired 10 to 15 lawyers. Now with AI, my lawyers are getting better and better and better each day. So if I have a strength of 45 lawyers, they are giving me a work of around 100 lawyers. So yesterday we were talking, Mr. Pavaya said, may you have 400 lawyers or two. I don't think so. We will require them in coming 5 years. My 40, 50 lawyers can give me that work if they can use AI as a very good tool. But going ahead, I think law firms who work on HNI and ultra HNI clients, they really do not want to go to court. But here is my question. I think going 100 years back, Arbitration Act 1940, before that, I don't know whether there was arbitration or not. There was pre-litigation mediation, which we have started. Do you see that a government will give any kind of affirmation to a pre-litigation done by any law office through an AI where two matrimonial clients, HNI, are fighting, they can put down their problems, all the assets, and whether women is working, not working, all these issues, can it be resolved through that? MSCT can be resolved, maybe contractual, can it have a government entity or an act which will come in future which will say that okay, what this AI has done has the backing. Maybe it can be challenged like an arbitration award is challenged, but do you see that?
I'll keep it very short. Very small comment, just a small question. Obviously, we're discussing efficiencies and inefficiencies, and I'm assuming that Sir said 15 years. I'm assuming within 5 years, AI will become so perfect, it will be great and good enough to go and do persuasive arguments also in court. My question is a little fundamental. what is the ethic then when we have a perfect AI of using it or not using it? I'm not saying that, you know, like back in the days we used to say computers will replace humans. They didn't. We just have our personal computers now. But what is the ethic? Should we use it or not use it? Are we redundant, or are we to do better things in life than sit across our computers and make list of dates? So maybe that mulling over.
My question is just related to hers. Today, I mean, lawyering is just not about drafting petitions. It's, I think, more about going into the courts and arguing. At least that's what we have seen in the last so many years, you know, the quality of arguments that used to happen in the courtrooms. So do you see that declining with the intervention of AI? And if not, then how do we prepare our youngsters to be prepared, you know, to be ready for that kind of courtroom skills and arguments? Yeah.
So I think if everyone, please.
Thank you so much. Myself, Vaishali Jadhav, and I'm basically a trial court practitioner and giving, right now, preparing for the advocate on record examination. So my basic question is, I'm a technology lawyer because earlier I was an engineer and turned lawyer. So thing is, the people, what they are speaking about AI, the AI is a basic LLM programming, and the ma'am said it is going to perfect. It is never going to be perfect. But thing is, my question about justice, the current, in today's scenario, the kind of evidences appearing in the court, which might be not reliable, and we don't have any standard operating procedure to identify those evidences. Even the judges, even the lawyers, the opponent lawyer doesn't understand, and they are vague about it. So I just wanted to know what our judiciary or higher court is doing for those standard operating procedure. So in order to get proper justice to the individual or litigants. Thank you.
So may I? So I think everyone agrees there needs to be a legislation for AI. And I would request a suggestion from each and every one of you. What boundaries should legislature put to these AI? Will it be an extent to the IT Act currently, or will there be a new legislation which puts on the ethics? So a suggestion for the legislation should be expected, please.
I'll start from the last one. We have a parliamentarian here who frames the country's laws. It's a question to him. Now, madam, so far as your question is concerned, I believe you are an advisor to banking companies. Now, so far as banking cases are concerned, you have your own laws, or, you know, mainly we are concerned with recovery of dues. You found that RDB Act did not work. SARFAESI helped to a certain extent, but thereafter we now have the IBC.
He spoke from the heart, sir.
So, left to me, our role is a bit restricted, isn't it? What is our constitutional role? We interpret the laws, right? And on the basis of our interpretation of different laws, it's for you to advise. I'll just give you an example. I'm reminded of a judgment which I delivered in Bombay. Now, you know, in SARFAESI, from 24th of January 2020, new chapter 4A was introduced with regard to registration with the search right. Who would get first charge was the question. You find so many statutes giving the department the first charge. Now, language used is different. SARFAESI came up with a different language. I don't exactly remember what the words are, but we interpreted in favor of the secured creditors. Now, as everyone says that we have become predictable in our approaches. What you know who is a pro-establishment judge, who is a pro-tenant judge. That was there long before. It's not a thing of the present generation, of the present decade. We all knew in the 1960s, 70s, and when the matters used to go before judges, we knew what would be the fate. So therefore, it's for the present, let us play the straight bat shot, staying in the crease rather than stepping out and hitting a six.
Very, very well put.
The other questions?
Yes. Yeah. May I just quickly take one or two questions? Madam.
Madam's evidence.
Yeah, evidence. Yeah, please. Okay. No, I know that. I kind of gathered what your question is. Yeah. See, no, the structure today. Now, in AI, a separate discourse and academic development in AI as almost a separate discipline now that's emerging is evidence transformation in AI. Not just from a courtroom lawyering perspective, simply in terms of efficacy of the evidence, the probative value of the evidence, and the evidence being made tamper-proof. For example, blockchain being used for evidence to make sure that it is tamper-proof, so you don't have to bring it to court to show the efficacy of it because it is deemed thereafter. But the problem for us as lawyers in the evidence transformation is that I think we are still very, very nascent on AI when it comes to evidence gathering, evidence usage, and more importantly, cross-examination. But as we speak, there are US companies building tools on cross-examination algorithms in AI to assist lawyers, because particularly, at least the litigative market in the US is very highly prone towards cross-examination given the jury metrics. But all of this, according to me, today is hypothesis, and we'll find an answer as we go along. And madam, the answer, the one-word answer possibly I can bring to you is, all of you, and I don't mean anything bad on or for or against consultants, but technology consultants really can add value provided you have efficacy of data for which you need an enterprise system. Unless you have an enterprise system, you can't go to a doctor and not tell him what your situation is and ask him to give you medicines. It's not, you don't go to a cardiac surgeon for a pathological problem. You don't go to a nephrourologist when you have a cardiac problem. Now, going to a consultant on AI, particularly from a court perspective, is our courts in this country do not have enterprise solutions when it comes to technology. We have a national judicial grid which is sitting on some NIC platform. We are using WebEx as a tool for our video conferences. Some other court is using Zoom. Do you have an enterprise solution on any aspects of your technology? Answer is no. Unless you do that, you will not build a data set which is efficacious within your enterprise for a machine to learn. And therefore, you can't teach somebody unless you have a teacher, and the teacher for you is your data set. And therefore, we should, as a judicial system, build that enterprise solution from ourselves if we expect AI to actually assist us in justice delivery in the next decade.
I wanted to answer your question about young lawyers, and especially because we are at a generation which is already removed from that. I think law schools have to start introducing tools which are in the market so that when students emerge into the market, they're already familiar with AI-based tools. That's really the competitive advantage which they have. Secondly, I think this is a very real problem. I mean, the kind of obsolescence which you've seen because of technology in other fields, you are now seeing in the law. And my point initially was that you've already seen that with photocopiers, with clerks, with stenos who have become obsolete because of technology. We are now having to ask ourselves those questions as lawyers, because definitely where you needed 5 or 10 juniors earlier, now maybe 2 are going to be able to do the job. The difference is going to be those who already know how to use the technology, who know how to use the prompt. And for that, learning at the university level itself is essential.
Can I just take that last question for 1 second? Yes. Only on the issue of legislation, which I think my friend had raised. Legislation, according to me, would be a bit of a problem. Because if you see the legislations coming out of our society for the past 15, 20 years, our legislations do not have the foresight that they should have. If you need legislation in this sphere, you need to have it with foresight. And according to me, as a society today, we are incapable of getting a legislation which has foresight. You had the Contract Act, you had the Evidence Act, both of which remained for over a couple of centuries. Right? Transfer of property. They lasted over a centuries, and those definitions, those concepts, the text of the act have outlasted centuries. Today, legislations which are enacted, in fact, lead to far more litigation and far more disputes than they are intended to solve. So if you want a legislation on this, frankly, I think you're asking for problems. I think the easier solution at the moment is self-restraint.
Yes, thank you. Yes, let us end this session. I thank each one of you for the wonderful conversations on the AI. Yes, and I'd like to, yes.
Before we close, despite the noise reduction panels, I was in the other hall with Justice Kurian and Mittal Saab. The laughter in this room, and they said they seem to be having a great time there. So what I say is, this is precisely why this conference was held. You have fun and you have domain knowledge. All the experts are here. We are deeply grateful to you.
Thank you, sir. And I would like to proceed with the memento. Please, kindly be seated. Just 1 minute. Yes. I request Mr. Mohammad Sadiq Hussain to give a memento to Justice Debanga Datta ji. And now I request Mrs. Divya Jain to give a memento to Mr. Sajjan Puya. Now, I request Mrs. Rowley to give a memento to Ms. Arundhati. And I request Mr. Tiket Badak to give a memento to Mr. Bari Ranganathan. Yes. And let us have one photograph clicked with all the panels.